Your Lordship,
Call the list.
Your Lordship, one mentioning Your Lordship.
What for?
For release, Your Lordship.
Yes,
Release the matter.
mention on Monday. Today is not the date for mentioning, unless and until it is extremely urgent matter. Please come on Monday. Call the list.
Item number 1.
Monday is a holiday day, no, either Tuesday or Wednesday. Yes.
Well, I am for the respondent Madrasa board. Well, we had a vacating application which has not been listed as yet.
It is the extended vacating application. If you want, that can be included in the list.
I am giving your lordship the vacating application to your lordship.
What about the main matter?
Main matter may be fees by your lordship any day. Yeah, I have to go to the hearing bench then, my lord.
Yes, because that is before Justice Banerjee. That is before Justice Banerjee.
Well,
That's
today,
why after taking all the matters on, keeping all the matters on board, I had to release those matters in view of the orders passed by Justice
Justice
Banerjee.
Rai Chattopadhyay. Justice Rai Chattopadhyay.
Yes.
It was mentioned before Justice Rai Chattopadhyay. Chattopadhyay নেবে কি?
পুরনো ম্যাটার তো নেবেই তো, অন্য ও তো ডিটারমিনেশন আছে 2022 এর আগের থেকে।
22 এর আগে ম্যাটার করতে 24 এর ম্যাটার কি করে নেবে? 14
When the interim order was passed, Mr. Dotto?
Interim order was passed
28
1st
November
June 2020.
or prior to that?
21st June 2020.
মানে there was a conditional order of Justice Tapoproti Chakraborty.
Now, what about the two teachers regarding salary bills?
They are getting the salary.
Regularized. They are getting salary.
Only one thing, I filed.
You are the teacher in charge.
যা বাবা।
Hey, who is it? But I tell you, I filed an application.
I have been.
Teacher is set up by the petitioner.
I am the person who has been approved by the DI, by the appropriate authority.
Oh,
He has been revoked.
no,
No challenge.
I know.
But I am.
So teacher in charge.
Teacher in charge who is issuing dictates
Yes.
under his letterhead. He's nobody.
I mean, he has
litigating and
he has issued this appointment letter in favor of the other teachers. He has issued. He has got no authority. That's why I filed an application, CAN number. But those two teachers are not going to the school by sitting home. They are
But those allegations are over. That was the initial allegation.
no, I had to pass 2 or 3 orders on last occasions.
Yes.
Because since those teachers are not getting salary,
They are
now
getting.
they are getting salary.
I'm getting salary, but I'm not allowed to enter the school.
Not allowed to enter the school.
But
See the conduct of the school management.
I filed an application. He's not going to the school.
No.
No.
that is not correct. In fact, police in action is.
that is not the purport of this.
And that's why I filed an application.
চট্টোপাধ্যায় করে আনিয়ে এখানে ঘুরে বেড়াচ্ছে এখান থেকে রিকুইশন করে নিয়ে চলে যাও
সেটাই করতে হবে।
14 নম্বরটা আর কবে
করবো,
করবে?
দাঁড়া, এই রমজান।
না এখানে এখানে হবে না,
না, এখানে হবে না।
রায় চট্টোপাধ্যায় হবে না, কারেন্টটা তারে ঢুকবে না রায় চট্টোপাধ্যায় 24 নেবে না সে।
ল্যাক অফ ডিটারমিনেশন।
হ্যাঁ তাহলে কি 24-এরটা কি করে ঢুকবে?
না, এই 2-3টে মামলা ঢুকবে না, কিন্তু ওই অ্যানালগাস মামলা 2006 আর 7 যেটা ইন্টারিম অর্ডার নিয়ে বসে আছে সেটা তো শুনানি হবে।
সেটা করে নে
ওটা হয়ে গেলে তো নিষ্পত্তি হয়ে যাবে।
না একটা ওখানে আছে পার্থপ্রতিম চ্যাটার্জি, পার্থ চ্যাটার্জি ধরে আছে, পার্থপ্রতিম চ্যাটার্জি ওই বিল্ডিং এ। নেবে কারেন্ট ব্ল্যাক সব নেবে তখন যেটা ইচ্ছে সব ওর কি আছে জানেন তার 2 বছর
আর জানি তো, ওই জন্য তো জিজ্ঞেস করলাম। স্বাস্থ্য শরীর ভালো হয়ে গেছে তো কন্টেন্ট নিয়ে আর কি।
যেখানে পারো করবে, ঠিক আছে।
On being mentioned by the lawyer advocate representing. What was the writ petition on which this was passed?
Appointment of an administrator.
কোন রিট পিটিশনে অর্ডারটা হয়েছিল WP নাম্বার
15894.
Yes, 15894 of 2025. Parties are represented by lawyer. From the submissions made on behalf of parties, it appears that there is no change of, there is no alteration of situation
154 of
24 তো as on date.
এইটাই তো মানে we have filed an application for vacating in the same writ petition.
You are for the board.
I am on the board.
You want to get it heard.
I want to get the application heard.
It is submitted on behalf of West Bengal Board of Madrasa Education that one application is
Can number 2 of 2024
can.
in WP number 15894 of 2024. WP 15894 of 2024 in which this interim order is extended.
One application being carried for in connection with WPA 15894.
Yes, madam.
Is
That's the resolution.
আমি আমার ক্লাস সার্ভিস করেছি জানো তো?
vacation of, no, for vacating, interim order, vacating. 21st June. Stop. Next paragraph. Subsection regarding
That to the
vacating application. Interim order passed on 21st June 2020.
সার্ভিস করা ক্যান টু এনাদের সার্ভিস করা হলো
Can extend it till 31st July to further order which is explain the prayer made on behalf of West Bengal Board of Madrasa Education. This the vacating application
ক্লাস নিয়েছিল
being carried
Chukar.
under the heading application in the monthly combined list of April 2020.
Only what the vacating application has not been served upon me.
ঠিক আছে দিয়ে দিচ্ছে
If it is not served, I will not hear.
No, only one can one. Can one, I filed an application, can one. But let it be listed along with the vacating application.
Can one is already appealed.
No, because application under the heading application, let it be also listed.
Can one for what?
Can one is a Firoz Khan is not going to the school. He is getting salary by sitting in the home.
I am not being allowed.
1 minute, 1 minute.
At the time of hearing, yes. Yes.
Then I have to file the writ petition against Firoz Khan. I will come before the council.
again.
Court will not hesitate to decide that.
Yes. What is not afraid of your application? We are great. ঠিক আছে
Item number 2.
Yes. Appeal.
Appeal is still pending.
I am for the
Now,
state.
my lord, Honorable Justice Jamal Bakshi has been elevated, so it has to be reassigned.
That one request that I filed one application. I filed one supplementary affidavit, but I want to take your lordship's kind.
Not at this stage, Mr. Bhattacharya.
No, I tell your lordship why. My lord, your lordship.
No,
has
not at the,
decided-
when I will hear the writ petition, then I will consider. Not at this stage, I have protected you. Let the interim order be extended for some time, but not at this stage.
My lord has decided the issue.
What?
In the case of Shimoi.
That is maintainability issue is not.
Then if I have decided the issue by an judicial order, then you will rely upon that order.
I have relied.
Yes, that for that supplementary affidavit is not required.
But the same.
If it's an order of court, you will rely upon a time of hearing.
Very. Understood.
Matter has come up in the list under the heading under the heading extension of interim order, quote unquote, on being mentioned by the learned advocate representing the petitioner. Stop. Next paragraph, Mr. Bhattacharjee, learned advocate representing the petitioner submits that interim order will expire today, comma 31st March 2025.
মেনশন করে দিলে উঠে যাবে।
Next paragraph. School authority and the state. We are for the
মানে
state. School authority and state respondents are represented by learned advocates. Next paragraph. Interim order passed earlier stands extended till 31st July 2025, 31st July 2025 or until further order. Next paragraph. Since school authority has preferred an appeal against the order, which order Mr. Bhattacharjee dated? 14th August? No.
This is the order.
This is not Priya Chakraborty's case.
No. And this is the order. That 25th of June 2024. Joshapati.
In this matter, no appeal is pending.
No, nothing.
What?
But they have questioned their whether
In
petition is
Priya
pending.
Chakraborty, appeal was preferred.
Yes.
তাহলে ওটা দরকার।
Point was taken.
Similar point was taken in this matter.
Acha, liberty to mention the matter by the learned advocates representing either of the parties.
That the matter is appearing as 555 in the monthly list. So well, it will go out of the list. It will go out of the list.
No, I have not finally decided the matter.
Very well. Now, my lord has said liberty to mention.
Oh, is it appearing in the list?
Is in the monthly list.
তাহলে দেখি অর্ডারটা একবার শুনি।
In the monthly list.
Then that liberty is not necessary. না, কেটে দাও ওটা। Let the matter retain its position in the monthly combined list of
এটাকে নিয়ে নেবো ফেরত?
April 2025.
I'm protected till July.
Yes.
Item number 3, my lord, pursuant to my lord's, my lord, should rule, my chairman, my lord, appear personally, my lord, I tender unconditional
Just a minute,
apology.
let me go through my
Yes.
own order. What is the present situation? Where is the contempt now?
Well, give me liberty to file a short affidavit. I shall explain everything, my lord. Since 2010, my lord, he is there. Never, my lord, happened this type of situation.
He is the chairman Barcode
Barcode
municipality. Ask him that why within time the order was not passed.
My lord, I asked him, my lord, I already, my lord, last occasion, my lord, submitted before lordship on 10
Why the
Jan.
municipality shall be dragged before this court in contempt proceedings.
No, my lord, never, my lord, first time, my lord, I facing this. My lord, first time, my lord. Well,
He is also holding a
with
responsibility.
great respect to this institution, my lord. He has everything, my lord. Earlier, any order passed by this court complied with, but this happened due to some, my lord, personal difficulty. Also, my lord, my lord, our superintendent, my lord, without, my lord, notice, my lord, absenting from the office, not duly communicated anything, my lord, to this, my lord, order of this honorable court. My lord, I personally, my lord, care of this matter.
Thus,
Yes.
writ petition was disposed
Yes,
of on
2000, yeah.
21st
Yes,
September
my lord.
2023.
There is no dispute, my lord. There is a delay.
I have recorded in my order
Yes, my lord.
that the 21st September period prescribed in 21st
Yes,
September
sir.
2023
12 weeks.
ended in the month of January
January.
2024. No steps. Then contempt application was filed, same was heard on 8 November 2024 and 6 December 2024.
Yes.
Nothing.
Only
On 6 December 2024, hurriedly an order was passed
Active,
without
active,
affording
active,
opportunity
yes,
of
yes,
hearing.
yes. That's why, my lords, my lord, give me liberty to press my proceeding.
So how do you reconcile this?
My lord, I tender unconditionally with fold, my lord, because in future, my lord, will be, my lord, very careful.
Should it not be termed as playing with the order of the
No,
court?
no, not intentional, not willful, my lord. My lord, praying before your lordship, never, since 2010, a first time, my lord, this situation, my lord, came up. Whenever order passed by this honorable court, we complied with, my lord.
Your municipality doesn't know how to initiate proceedings under section 218.
My lord, that is the, my lord, communication gap, because the all proceeding was taken up by the office superintendent under the, my lord, care of the office superintendent. My lord, what happened was,
Is it the job of the office superintendent
No, my
to
lord.
initiate proceedings under section
no
218?
proceeding, not he communication to the board of councillor to initiate proceeding. There is a gap because without my lord, unauthorized absent, my lord, entire, my lord, system, my lord, collapse, my lord. That's why. Otherwise, we have great
So the
respect before
system
this.
of the municipality has collapsed.
No. System, the
Then-
procedure, my lord. That's why, my lord, some delay occurred, my lord. That is
21st
undisputed.
September
Yes,
2023 order.
This is undisputed, my lord.
Time expired
Yes.
on in the month of January 2024. Month of January 2024 time expired.
Yes, my lord.
Then contempt application was filed on 23rd July 2024. Please note the dates. And same was heard on 8 November 2024 and 6 December 2024.
Yes.
On 6 December, an order without granting any opportunity of hearing. In the name of initiating proceedings under section 218. Is it the purport of section 218
No,
of
hearing
the
was done, but
West Bengal
recording,
Municipal
the
Act
reason order was not there, but a cryptic manner order was passed. That's why your lordship asked me to see the order. I have gone through the order. Thereafter, I caution that should there be proceeding should be in terms of the 218 recording must be there, and my lord expression must be there, my lord. That's why, my lord, give me, my lord, short time to file everything, my lord. I shall explain my affidavit, my lord. And my lord, in future, this type of, my lord, situation will not be happen, because I, my lord,
So what is the
personally,
present situation regarding, or rather, what is the present stage of these proceedings
my
which
lord,
is required to be initiated
that,
under the
that
order
was
in
done
terms of-
6 March, my lord. 6 March that was done.
What was done?
Hearing was done. Yes.
Petitioners were granted
Petitioner,
opportunity
yes,
to-
petitioner and private testimony both appear granted, my lord, opportunity to hear, my lord, to place their case, my lord, that is recorded. That is recorded, my lord.
Yes.
I shall, my lord, file compliance report, my lord, by affidavit.
Yes.
My lord, on 6 March 2025, my lord, my learned friend went there to attend the hearing along with the petitioner. When the hearing was done, he was thrown out. Practically, he was thrown out. No hearing was done. That's why, my lord, I have requested him to come before your lordship. That now, then, my lord, what happened? My lord, what is the conduct of the particular chairman, my lord?
Yes, that you made specific submissions on that last occasion.
My lord,
I still remember. Mr. Das, do one thing. Tell your chairman to hold another date of hearing.
Yes.
Give them an opportunity.
Yes,
to
my
make
lord, I have
deliberation
no objection. I have
the-
no objection.
to the satisfaction
Yes,
of the
yes,
parties,
yes.
and then pass an order in accordance.
Yes, I have no objection. Yeah. Well, whatever your lordship think, my lord, kindly, my lord.
I will grant you opportunity
yes.
to file an affidavit of compliance,
Yes.
giving you ample of time,
Yes.
so that another date may be fixed
Maybe fixed.
for further hearing
Further
in
hearing.
connection with the proceeding under section 12.
Opportunity of hearing to all sides.
Appropriate opportunity of hearing.
Recording the
Then
reason.
take steps and file an affidavit. of
Yes,
compliance.
everything will be done.
Right.
Under my
But
care, my
don't
lord.
throw out
I
the
personally, my lord,
parties
I personally take up
that
this.
why you have filed a case before this court.
Yes. No, my lord. What happened, my lord? I frankly, my lord, speaking that since, my lord, one complaint, my lodge against him.
You know, on the next date, I will
against her.
take stock of it. That whether
No.
there was satisfaction so far the learned advocate
Everything, my lord,
are
everything will
concerned
be recorded.
making
Yes.
deliberation before the chairman.
No, my lord. I, my lord, personally take care of the matter. My lord, no, nothing will be, my lord, happen. My lord,
My lord,
your lordship asked me to my lord, for special care in the matter. That's why, my lord, kindly give me my opportunity. I shall, my lord, ask my chairman to conduct a fresh hearing to, my lord.
Fair hearing.
Fair, obviously fair, my lord. When order of the court is there, everything will be fair, my lord.
my lord,
I pass.
In the guise of hearing, not to insult the
No, more, nothing,
parties.
nothing more, my lord.
my lord, one little.
My lord,
My
my
lord,
lord.
short submission, my lord, I have to make, my lord.
Well, first time it happened, but since 2010 he is there, my lord. No allegation against him, my lord.
No, why in a contempt proceedings court has to
Well,
pass
that
an
should be avoided, my lord.
contempt rule
Yes.
against the chairman?
Yes, my lord. That
He's not an
proceeding.
illiterate person.
I do not support it, my lord. Personally, my lord.
My lord,
I do not support
my
it.
lord, kindly see the conduct. My lord, after issuing the
I
rule,
have heard you
no, my lord,
extensively last occasion.
one submission, my lord, kindly see the, my lord, conduct of
Yes,
this
today
chairman.
he is submitting that another date is to be fixed for
Yes.
hearing.
Yes, my lord.
Well,
You make fullest deliberation
I am,
before the
I am
chairman.
pardon, my lord.
And an
But
appropriate
yes,
order to be
Kindly,
passed in
my
accordance with law.
satisfaction, my lord, kindly let me make my one line submission. My lord, after issuing the contempt rule, my lord, this chairman issued a notice for giving a hearing. In the name of hearing, my lord, issued a notice to Jutika Pal that your a proceedings will be initiated against your premises.
That is
My lord,
another
kindly
proceeding, my lord. That is on the basis of the complaint.
That is not the subject.
That is not a subject matter of this complaint.
After issuing contempt rule, that is my submission. After issuing contempt rule, this letter was issued. Well, your building should be demolished fast. This is the language of the chair.
Well, no. কোথায় চিঠিতে কোথায়
Last hearing when was conducted?
6 March.
So rehear the parties.
Yes,
also
my
the
lord.
proceedings.
Yes, my lord. Your lordship ask me, I shall take care, my lord.
He is Uttam Das.
Uttam Das.
Pursuant to the rule issued by this court on 7th March 2025, alleged contender number 1, Uttam Das, Chairman, Barakpur Municipality, is personally present in court. Stop. On behalf of alleged contender number 1, it is submitted that in connection with the proceedings under section 218 of the West Bengal Municipal Act 1993, another opportunity shall be granted to the parties, including the applicant, to make deliberation before the concerned authority of the municipality on a subsequent date. Shall I fix up a date?
My lord,
No, you do
yes,
according to.
yes, my lord. That after my lord say 16 because some holiday is there, my lord.
কি বলছিলাম দেখো তো।
হ্যাঁ আমি কি বলে আমাদের করছি আমরা ঠিক
Under section 218, on a subsequent date, an adequate notice shall be
Yes.
served upon the parties. Stop. It is also assured before this court that after the hearing in accordance with law, proceedings under section 218 shall be concluded strictly in terms of the order passed by this court on
21st.
21st September 2023. Alleged contender, through his learned advocate, has tendered unconditional apology for causing delay in concluding the proceedings in terms of the said order dated 21st September 2023. Stop. Next paragraph. In view of such submission made on behalf of alleged contender number 1, hearing of this contempt application stands adjourned till second May 2020 till 2nd May 2024 2025
মে মাসে দিয়ে দেবো
for filing affidavit of
Yes.
compliance. Personal appearance of alleged contender number 1 stands dispensed with for the time.
Yeah.
being. Yes, if necessary on the next date, you place it before.
fair hearing shall be there.
Yes.
I undertake it. I deeply oblige you. Yeah, তোমার কত? 4.
ওখানে দিলাম দেখো এটা অ্যাপিয়ারেন্স গুলো দেবেন
দিয়েছি।
আইটেম নাম্বার 4
For Miller, this contempt Miller, the order has been complied.
My lord, it has been complied with upon the grace of my lord, family has been saved.
She was taken the initiative, let's go that.
দুই পাঁচ
Shweta,
Now the treasury officer has released them following the ratio as indicated in the legal year certificate. Issue. Both learned advocates representing parties have jointly submitted the order passed by this have jointly submitted that order dated 17th April. Order dated 17th April stands complied with. Stop. Next paragraph. In view of such submission, contempt application stands disposed of and contempt proceeding stands to.
Yes, friends.
Item number 5.
My lord, item number 5, my lord, I am for the contemptor, my lord. On last occasion, your lordship directed me to file affidavit in compliance. My lord, my learned friend, my lord, is, my lord, submitting the affidavit of compliance. Order has been complied with, my lord.
Yes, complied with.
I don't know, but let me go through the
You
report.
don't know means
We have not received the report,
the
lordship.
compliance you should aware of.
We have not received it, lordship. Report.
What was the order? Just a minute.
My lord, kindly come to page 23. Order dated 18 December 2023.
Yes, just a minute. Considering the nature of chapters. Chapter. Disposed of. Have you passed order?
Yes, my lord, kindly
Yes.
come to page 5 of my compliance, my lord, affidavit of compliance. Page 5.
Let me go through the report, lordship, first, then give a date also. Chairman change হয়েছে না?
Yes, order is passed. Therefore, the person responsible is directed, it's wrongly typed, indirected, it should be is directed to remove all converted area into parking area within 2 months from the date of communication of this order.
I have not got any information, lordship.
Yes,
I have not got any information, lordship, and I'm not
so if you do not get any information for that, court will not wait. This is an order dated 26 March 2025.
Yes, lordship, but I'm not the aware. That is why.
Issue.
appearance গুলো দেন
An affidavit of compliance is filed on behalf of the alleged contender number 1. Your applicant has got the relief.
Yes,
That's why you are not getting any information.
that is
yes sir
fine. I've just informed that.
কি বললেন affidavit of compliance? And same is taken on record. Stop. Next paragraph, on perusal of the on perusal of affidavit of compliance, it appears that
যেহেতু রিলিফ পেয়ে গেছে
alleged contemner on perusal of affidavit of compliance, it appears that concerned authority of Panihati municipality has passed order dated 26 March 2025. Stop. Next paragraph. Therefore, the order passed on 18 December 2023 in the connected writ petition is complied with. Next paragraph. Hence, contempt application stands disposed of and contempt proceeding stands dropped. Urgent xerox certificate copy.
Grateful, your lordship.
Next.
Grateful, my lord.
Item number 6.
At the time of call, no one appears for the applicants. And no accommodation is paid for. Previously, next paragraph. On 7th March 2025, on the prayer made on behalf of the applicants, hearing of this contempt application was adjourned in order to enable the learned advocate for the applicants to obtain instructions. Next paragraph. It appears applicants have lost faith in the fate of this contempt application. Next paragraph. Contempt application stands dismissed. Parties to act on server copy of the order downloaded from official website of this court.
Item number 7.
7, an appeal has been referred by my client that is pending before the Chief Justice. Now I will let it go out of this.
It has been assigned by the Chief Justice.
Assigned as a normal course, it has been assigned.
No, I cannot keep it for an indefinite period out of this. Sorry.
Difficulty
It's not a normal course, it has come.
Difficulty is, my lord, that there are twofold direction of the learned trial judge. That
Take steps. I can grant you time.
sometime, give some 3 weeks time.
Appeal against the order passed by this court.
That is Sanjeev Banerjee. My property land was taken over by putting a flag on my land. I came up before this court. I am a recorded owner. I pay tax. But the learned trial judge has said, well, my lord Justice Sanjeev Banerjee has said, my lord, that no one will go to the land. You file a civil suit. But that
Has been assailed. There was no stay.
No, appeal court did not stay it. Appeal court not yet stayed it.
What was the direction given by the appellate court?
Yes, appeal court order.
Show me the order of
Court
the
fine.
appellate court.
Trial করে
Appeal court pending. Appeal pending. Nothing, not taken up by the.
Never heard.
Never heard. Never heard. Now, why I filed the contempt? There was an injunction, nobody will go inside the land. He has gone inside the land while violating the order of court. That private protest college. And made construction of building. I had to file a contempt application. Where should I go again?
So you have preferred an appeal against this order and you have also filed a contempt.
I appeal only for going to a civil suit. As a recorded owner, why should I go to the civil suit for dismissal act? I'm the owner of the property. Political intervention has taken place for throwing me out of the position. I could not convince my client that you go and file a suit. But why should I file a suit? I am an owner.
So you are protected by this order, Mr. Bhattacharya. What remains? There will be an injunction restraining. Do you have the copy of the order? Please read the second page, penultimate paragraph, or
There will be an injunction
second last paragraph.
Any party from putting up the construction on the relevant plot of the land so and so for a period of 2 years from the date or earlier ordered in the appropriate civil court. It will be open to the petitioner here or any other person interested to apply before the appropriate civil court and assert right over the land in question.
Still you are in possession of the land.
I am not in position. I have been thrown out of it.
So what? Then the civil court has the remedy lies before the civil court for asserting your right over the land in question.
Now record has been changed.
Now this order was, see the position. This order was passed on 30th July 2020. You have preferred an appeal, but appeal was not moved. What remains?
Keep it not pressed. No.
Issue. It has been submitted by Mr. Kamalesh Bhattacharya, learned advocate representing the applicants, that the contempt application is not being pressed. Stop. In view of such submission made on behalf of the applicants, Writ petition contempt application stands dismissed as not pressed. Parties to act on the server copy.
Item number 8. My lord, I am for the School Service Commission.
At the time of call, no one appears for the petitioner and no accommodation is paid for. However, West Bengal Central School Service Commission is represented by learned advocate. Next paragraph, the writ petition stands dismissed for default. Parties to act on server copy.
Deeply obliged. Item number 9.
I'm for the state respondent.
This writ petition is preferred for, my lord, considering her prayer for HRA, grant of, my lord, resident allowances. My lord, I have served upon all the respondents. All of them have been delivered long back. Long back means, my lord, in first week, second week of March. But here, my lord, the state subject to correction would be the answering respondents. But what happens here, Lord, initially, my lord, when the petitioner was working in Jalpaiguri, at that time, my lord, her husband, who was working in the GST authorities under the government of India, so my lord, was there posted over there only. And accordingly, he was, this incumbent was not entitled to HRA.
Since husband was drawing HRA.
HRA. There. So after that, my lord, her husband.
Both were staying at the same place.
Yes, at the same place, Jalpaiguri, somewhere around. So, my lord, after that, my lord, the petitioner, my lord, the husband of the petitioner was transferred to Kolkata. So, my lord, then she became entitled to the HRA and made the prayer to the school authority. Accordingly, my lord, the school authority took the resolution that she should be granted with the full HRA and forwarded it to the district inspector. The district inspector also, after verifying, forwarded the same to the Commissioner of School Education, which that is not being considered, my lord, till today. My lord, that is one.
School is in Jalpaiguri.
No, my lord, that was the first school. Now she is there here.
Which school?
Now, my lord, she is once again transferred here in Kolkata.
Oh, where?
Yes. My lord, now she is working, I tell you, lordship, respondent number, my lord, 9, which is, my lord, page number 3, that is in Jadavpur, Kolkata.
Yeah.
So now, thereafter, my lord, that is the first part of her claim. Now, when she came back to Kolkata, she was also became disentitled to HRA since her husband is also staying in Kolkata. Thereafter, my lord, her husband once again was transferred to Haldia. So, my lord, she once again became entitled to HRA subsequently. So, she made
the intermittent entitlement and disentitlement.
So, I tried to prepare one chart, my lord, for better understanding of myself, my lord.
So, make indicate these things.
I have
approach
already.
The DI. Let DI take a decision.
I've already done that. This
Where is
what
your
my
representation?
My lord, my last representation, your lordship would see at page number
44, lordship.
44.
Annexure P5.
But before that, only one document which I request your lordship to see.
Both spouses,
Think about
lordship.
this situation. Previously, petitioner and her husband was staying at Jalpaiguri. Now, their husband transferred from Jalpaiguri to Kolkata. Now, the entitlement of the petitioner to draw HRA accrued in Jalpaiguri in connection with her service in Jalpaiguri.
Yes, true.
For that, you file a petition before at the circuit bench at Jalpaiguri.
My lord.
And subsequently, when you got transferred to Jadavpur,
part of the cause of action is
yes. So therefore, so far your service in Jadavpur school, I am done.
Well, part of the cause of action is before your lordship. But so I made the representation in Kolkata, which
So that will be confined to your service in Jadavpur.
But kindly, my lord, do not do this, my lord. I'll be, my lord, in trouble. So, my lord, one page I was trying to take your lordship to, but now I think I should not, my lord, take your lordship, which is page number 28. That is, my lord, the district inspector of Jalpaiguri.
Otherwise, which is the greater period of entitlement? Is it in Jalpaiguri or in Kolkata? If Jalpaiguri constitutes greater period, then approach circuit bench at Jalpaiguri
Jalpaiguri, my lord, is having my lord, more period than this Kolkata.
Yes, then
But my lord, kindly appreciate here only one thing. I just- because this is a part of the cause of action subject to correction.
file an application, get it numbered, go to circuit bench, do the matter.
But kindly wanna take this representation once because this has I have made this because I tell you
How can I?
I tell you also one thing, the district inspector forwarded it to the commissioner of school education with respect to the first part. So that is not considered. Page number 28.
Yes,
Page
page number 28.
This is with respect to the Jalpaiguri part. Page 28. Can you see this once?
How I can take up this matter?
But it is relegated to the commissioner of school education now.
But in connection with your service in Jalpaiguri,
That part, my lord, yes, it is not yet considered.
if you restrict your prayer to your entitlement in connection with your service in Jadavpur school, then I can consider it.
My lord, if, my lord, as long as my lord, that will not disentitle me to claim in
Better,
Jalpaiguri.
Mr. Rai, instead of going into these details, let me direct the Commissioner of School Education to take this. You go there, make deliberation there, based on your representation dated 30th September 2020.
Grateful.
Yes.
That will do, man. Grateful.
Your husband is a central government employee.
Yes, he works in GST, the affidavit of service.
Issue. Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Grievance of the petitioner is periodically. A grievance of the petitioner is for separate periods of service which petitioner has rendered in different schools in different districts. She is entitled to receive house rent allowance. However, it is candidly admitted by the learned advocate representing the petitioner that continuously petitioner is not entitled to receive house rent allowance, since at some point of time petitioner was residing with her husband, who is a central government employee, or who is central government employee. Therefore, who is central government employee? Stop. Husband was drawing house rent allowance, as a result whereof petitioner was not entitled for particular periods to draw house rent allowance. When petitioner was staying with her husband. Stop. Now both are staying at Kolkata.
No. Now, my lord, again she became entitled because her husband is once again transferred.
Where?
Haldia.
Stop. It is further submitted that at present petitioner is entitled to receive house rent allowance, since husband of the petitioner is working at Haldia and petitioner is working in Kolkata. Next paragraph. Indicating details of such periods when petitioner was entitled to draw house rent allowance. One representation has been made to the state authorities, including Commissioner of School Education, West Bengal, on 30 September 2024, and same is pending for consideration. Next paragraph. State respondents are represented by learned advocate who has submitted. Since the issue is pending before the state authorities, a direction may be given for consideration of same in accordance with law. Next paragraph. Having considered the submissions made on behalf of the parties, writ petition stands disposed of, directing the Commissioner of School Education, West Bengal, being respondent number 5 to take decision on the representation of the petitioner dated 30 September 2024, which is at page 44 to which is at pages 44 to 46 of the writ petition by 12 weeks from the date of communication of this order by passing a reasoned order. Stop. Before taking decision, petitioner or her representative shall be granted opportunity to make deliberation before the respondent number 5. Stop. The decision to be taken by the respondent number 5 shall be communicated to the petitioner by 10 days thereafter. Next paragraph. Urgent xerox certificate copy.
Great.
Item number 10.
For the petition.
And for the commission.
But this is. This is the affidavit of service. The school is also served in 12th of March. But it is an application for transfer. But I must candidly submit to your lordship that the school's representation is required here. Because the school once issued a show cause letter to me by saying that why I am not attending regularly. That was the case, but though that was not the ground for rejection of my case. But if the school.
What is the status?
Page 23, Lord.
23.
Page number 23. Lord. My application with this last application, serial number 1.
But it appears that managing committee has not given no objection to you.
But it has been, they said that they will not be.
As per managing committee decision, you are not eligible.
This is what they have.
Proceeding is pending, you are not eligible.
No, that is my point before this on report, that there is no proceeding pending. Because as per my lord, memo of 214, my lord, of 2018, my lord, the school cannot, at the first instance, second, they cannot even issue the show cause, subject to correction. But, and my respectful submission before your lordship, that they did not even communicate any such decision to the board yet.
Issue. Affidavit of service filed on behalf of the petitioner is taken on record. Stop. Grievance of the petitioner is last transfer application made on portal on 8 November 2022 was not forwarded by the authority of Mozampur Mozampur HSSB High School, Malda, being respondent numbers 6 to 9. As a result whereof transfer application is kept pending till date. Stop. Next paragraph, state respondents and the West Bengal School Service Commission are represented by learned advocates. Next paragraph, considering the grievance of the petitioner, this court desires to hear authority of Mozampur HSSB High School, Malda. Stop. The learned advocate for the petitioner is directed to communicate this order. Next paragraph. The learned advocate for the petitioner is directed to communicate this order to the respondent to the school authority, to the aforesaid school authorities, being respondent numbers 7 to 9 by 10 days from date.
My lord.
and file affidavit of service on the next date. Next paragraph. Next, list the matter under the heading motion. On 17th April 2025 for further consideration. Next paragraph. It is made clear if in spite of service of notice, authority of Mozampur HSSB High School are not represented on the next date, appropriate order shall be passed for ensuring presence of the school authority before this court on the next date.
Great.
Item number 11.
But I am for the respondent number 8.
And for the respondent number 9 also.
This is a matter regarding, I am the first wife and my husband, he was the ex. And it's getting pensionary benefits. And in that pensionary benefit, I find that my name is not included as the recipient. Somebody else, the respondent number 9 has been described as the wife. Whereas I am the first wife, I have got married in 1993, 28th of June, 1993. If your lordship sees where my page 31, it starts. I got this information from RTI because I got information from, so I made an RTI, and after getting the RTI, I find that the name of Putul Nondi, the respondent number 9, has been described as the wife. Whereas I am the wife, my marriage.
So this court will not determine who is the wife.
Yes.
You have to approach the appropriate civil court for a declaration.
My lord, I'm asking that this name, especially in the records, that be changed. Because she cannot be described as the wife. That's my grievance.
Where is the marriage certificate?
Marriage certificate was not there, but page 27 is the marriage. If your lordship sees, this is the marriage that took place on 20.
Photograph will not do anything.
Because it is under the Hindu Marriage Act, section 7. If your lordship sees, section 7. Section.
Oh, sorry.
My application is premature because my husband is alive. He is getting pension.
There is no family pension.
Yes.
In that case, the wife name has been given. So for this reason, he is apprehending that he will not get the pension.
No, I am apprehending because this is,
The teacher is alive.
That this writ court cannot decide.
But what I am trying to address your lordship is that the name given before this authorities is incorrect.
Affidavit of service filed on behalf of the petitioner. Petitioner is claiming to be the first wife of whether the retired teacher is party.
Yes, respondent.
I am appearing.
Teacher, you are the retired teacher. কি বলছিলাম? Yes. Approach the appropriate forum.
Civil court.
Yes.
It matters at 20. Your lordship, as far as this is concerned, it is relating to government.
First wife of respondent number 8, and the grievance of the petitioner is after retirement of respondent number 8, he is getting pension, but in the service in the pension documents, petitioner's name has not been inserted as nominee, whereas another name of another lady has been inserted. Another name of another lady has been inserted.
Described as the wife.
Page 47.
And declared as wife.
32.
47.
And declared as wife. Stop. No marriage certificate is enclosed to this writ petition, based on which grievance of the petitioner can be examined. Stop. Next paragraph. It appears that it is an issue where petitioner is claiming to be the wife of respondent number 8, whereas respondent number 8 has declared another lady as his wife and nominee in connection with he's declared as his wife as well as nominee in the connected service records. Stop. Next paragraph. Next paragraph. Therefore, no relief can be granted to the petitioner on this writ petition. However, this order shall not preclude the petitioner to approach the civil court seeking an appropriate declaration. Stop. Writ petition stands dismissed. Next.
From Monday, from Monday, heavy part.
Why? Primary, para teacher, secondary, higher secondary, madrasa. Everybody.
Just we are watching everything. Only college, this is that.
Item number 12.
I'm for the state, your lordship. Yeah.
Yes.
But I am for the my lord petitioner. But before starting, my lord, the respondent number 11, my lord, I make prayer to expunge this name, my lord, because the erstwhile school.
Justice Sengupta has been given bail matters.
Yes.
Justice Sengupta
Yeah.
determination gone to the Bashar.
Yes.
My lord, before starting, my lord, the respondent number 11, my lord, I want to expunge the name of the 11 because, my lord, no way this is connected with this petition, my lord. On 11 years back, my lord, he was serving that school. This is a transfer application. My lord, kindly come to my lord, page number 64 and 65. In Otshrosri portal, the petitioner is a headmaster of a school. Petitioner made application through Otshrosri portal that was back and with a request that you made another application since your choice, 3 choice of schools is already filled up. My lord, thereafter Otshrosri portal, my lord, stopped, and thereafter petitioner made offline application through an application dated, my lord, 12 February 2025. That is at
Now, what do you want? Transfer.
Yes, your lord.
Where is the status?
My lord, page number 65. At the bottom. May I read?
Page number 65.
Yes, your lordship. This is a screenshot, my lord. My lord, at the
But
bottom, the
date is
reason is
nothing is there.
my lord, at the top, my lord, general transfer application back from DI, general transfer application back from WBSSC. The applicant may be requested to submit, resubmit his prayer for transfer, selecting new schools since there is no vacancy in preferred school.
Yes. So there is no vacancy in the school,
Has-
preferred schools.
Yes, my lord. That's why the petitioner resubmit in page number 66, my lord. That may be considered. Lord, mention this new school, my lord. Two choice of the school, my lord. The second last line.
When this intimation was made,
To me,
page 65.
my lord, kindly come to my lord, page number 66. I have mentioned when I received, my lord.
Page 64, my lord.
My lord, and 65 I specifically mentioned.
But general transfer application back from PI, my lord, date
10th of May 2022.
Thereafter, my lord, transfer.
And you are making an application on 12th February 2025.
not in prescribed form as well as
Yes,
the
it's a
procedure.
new application.
Directly filed the application before the commission.
Thereafter, my lord, the portal was, my lord,
It's not a continuity. There cannot be any continuity because it says general transfer application back from West Bengal School Service Commission. The applicant may be requested to resubmit his prayer for transfer, selecting new schools. That is through portal.
yes, your lordship.
That was through portal.
Kindly come to
Now
my lord, page
there,
number 66. my
that
lord, once.
application ended, disposed of.
Kindly come
A
to
fresh transfer application is required to be filed.
kindly come
Now
to my lord,
that
page
fresh
number
transfer
66.
application you have made on 12th February
Kindly see
2025.
the, my lord,
That
second
is not
paragraph,
in
last
form.
line.
So therefore, this no relief can be granted to you.
Kindly come
It is
to my
not
lord,
in form.
paragraph
So,
2, my lord, second. Or kindly give liberty so that I can, my lord, made in prescribed form.
Affidavit of service.
Yes, your lordship.
Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Petitioner made an application for transfer
On
in
medical ground.
2022. Which was sent back to him since there was no vacancy in the preferred schools which were indicated in the transfer application. Subsequently, after a period of precisely after a period of 3 years, petitioner has made another transfer application in offline mode on 12th May 2025,
12th February.
and it is submitted on behalf of the petitioner that as he was intimated on 10th May 2022, that there was no vacancy in the preferred schools, which has prompted the petitioner to prefer this offline application on 12th May 2025. Petitioner prays for necessary direction for consideration of this offline application dated 12th May 2025. Which needs to be treated as in continuity of previous transfer application which was made in 2022. Stop. Next paragraph. Such submission made on behalf of the petitioner is opposed by the learned advocates representing West Bengal Central School Service Commission and state respondents. And it is contended that the transfer application which was made in 2022 was disposed of, and petitioner could have made application for transfer online through portal within the lifetime of the portal. So once that was not done, petitioner has no right to be considered for transfer. Next paragraph. Having considered the respective submissions made on behalf of the parties, this court finds that it is true that petitioner made an application for transfer in 2022, but due to absence of vacancies in the preferred schools, or due to absence of vacancy in preferred schools, singular, prayer for transfer of the petitioner could not be considered, and state transfer application was disposed of. Subsequently, petitioner has made an application for transfer in offline mode on 12th February 2025. And on perusal of same, it appears that it is not in prescribed form. Next paragraph. Stop. Next paragraph. Next paragraph. No, stop. Continuous. In this regard, reliance is placed on the order of Honorable Division Bench dated 14th February 2025, passed on FMA 103 of 2025, within bracket Tanushree Karmakar versus the state of West Bengal and others. Stop. Next paragraph. In Tanushree Karmakar Supra, right. In Tanushree Karmakar Supra, it has been observed by the division bench, by the Honorable Division Bench, that once a thing is required to be done in a particular manner, it should be done in such manner and not otherwise. Stop. The moment the form is prescribed in the rules shaping an integral part of the statutory provisions, it cannot be whittled down, not to be done away at the behest of the beneficiary of the said rules, nor the other stakeholders of the said rules can dispense with strict adherence of such statutory norms. Next paragraph. In absence of transfer application in prescribed form, this court finds, in absence of application in prescribed form, no relief can be granted to the petitioner. Stop. The writ petition stands dismissed. However, this order shall not preclude the petitioner to take steps in accordance with law seeking transfer. Urgent Xerox certificate copy. এটা তো তোমার লাগবে না, পড়া আছে। Respondent number Who are they? I have dismissed the writ petition. It's not required. Yes, next matter. If I would have entertained your writ petition, then question would have been different. Yes.
That is 12 February.
12 May. Yes, 12 February. দেখো তো 12 May করেছি, হ্যাঁ 12 February করে দেবে। আমি শেষে 12 February করেছিলাম, দেখি না। Yes.
Item number 13.
This is also transfer application.
Same, my lord, only the date is
Same issue.
same issue.
21st January.
Dates are different.
21st January 2020.
Page 34. Is the now.
The offline application only. On previous occasion, petitioner was made application.
Just a minute. Where are the dates?
Page 34, my lord.
Page 34. And the previous transfer application?
That is no connection because this on medical ground on previous occasion, distance job, it was not being transferred due to low skill. And this time,
It's a new transfer application.
No, my lord, it is, I regret to inform you that I have applied for transfer.
It's very ছোট করে করে দাও। She is not claiming to be in. She is not claiming that this is in continuity of his
As you,
of previous transfer.
as you lord.
on medical ground.
Affidavit of service. Medical ground.
The offline application.
Dated 21st January 2025 is on medical ground. Learned advocate representing the affidavit of service filed on behalf of, you are for the state, Mr. Dotto.
Okay.
Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph.
I have to travel long journey. And
Petitioner has made an application for transfer on medical ground
and
on 21st January 2025 in offline mode. Prayer is made for consideration of such transfer application by the concerned respondent authority. Stop. Next paragraph. Such prayer is opposed by the learned advocates representing respondent authorities. Since issue is decided by the Honorable Division Bench, video order dated 14 February 2025 in FMA 103 of 2025 within bracket Tanushree Karmakar versus the state of West Bengal and others. Stop. In the order dated 14 February 2025, it has been decided by the Honorable Division Bench that applicant teacher is required to file transfer application in prescribed pro forma in terms of the relevant statutory rules, failing which consideration of transfer application may not be considered. Now, failing which consideration of transfer application cannot be made. Next paragraph. While take it up. On pursuing the transfer application, on perusing the transfer application dated 21st January 2025, which is at page 34 of the writ petition, it appears that transfer application was made not in prescribed pro forma. Stop. Therefore, the issue is covered by the order of the Honorable Division Bench dated 14 February 2025, passed in Tanushree Karmakar Supra, wherein it has been observed. Next paragraph. In absence of transfer, next paragraph, in absence of transfer application in prescribed pro forma, no relief can be granted to the petitioner. Stop. Writ petition stands dismissed. However, this order shall not preclude the petitioner to take steps for to take appropriate steps in accordance with law for his transfer or her transfer, for his her transfer. ফর্ম করো ফর্মই করো দুটোতেই ফর্ম করো yes next matter
Item number 14.
Time for the state respondent.
who is for the petitioner
My lord, I am for the petition. My lord, the short issue involved in this matter, my lord, my petitioner's access to the transfer portal has been locked. And this was, there was a background because of such locking. My lord, previously there was
transfer portal is locked
yes access to the transfer portal. Now, my lord, the background is, the background for such locking is that, my lord, previously, my lord, there was a mutual transfer order. My lord, what happened? I am ready to, my lord, avail the mutual transfer order, but my partner in that mutual transfer order, he had
reside
my lord, one lady, my lord, she had refused and because and she had tendered her resignation. She had tendered her resignation from his service of assistant teacher. She joined, my lord, government service. Now, because of that, the transfer previous
there is 5 years bar
my lord,
once transferred on mutual ground no further transfer for 5 years
but
7 years
only issue, my lord, that order has not been implemented because of that particular incident happened.
inability on the part of your partner to
Yes.
be to take to accept the mutual transfer application
Because I have
order
no fault on my part. My lord. Now, since that period, my lord, this my lord, access has been locked, and my lord, I am getting some opportunities. Where some people are giving me request that you can avail that mutual transfer order, but because of such locking status, my lord, I am not able to do anything. My lord, I have made repeated representation to the authorities, my lord, to consider my prayer. My lord,
who is to consider
my lord, the
mutual transfer
my lord, page 25.
service commission
My lord, perhaps the department
by the state of
Department of School Education Department.
yes Mr. Das petitioner is not at fault allow him to have access to the portal seeking transfer on mutual ground.
My lord, since the portal is suspended,
different aspect.
my lord, offline can his case may be considered an offline mode. My lord can direct the
No, have you applied for transfer?
My lord, I can because of this locking status, I cannot because the mutual
No,
transfer.
but today the position is this so for the transfer, not mutual transfer.
Yes.
But the normal transfer
Yes.
portal is closed.
Normal time.
So therefore, you don't have any access.
Yes.
So have you got any opportunity to be transferred
My lord,
mutually?
I try to get the opportunity for mutual transfer, but because of this issue, my lord, I am not able. Mutual is, my lord, for the timing, mutual is in operation.
Where is the
My
mutual
lord,
transfer order?
Page 23.
Page 23.
Page 23, the first applicant, the petitioner. The second applicant is the Orpita Mondal. She had.
So Orpita Mondal recanted.
Yes, page 24. She had tendered her.
Very next day she resigned.
She resigned.
That's why, my lord, this order could not be complied with. Now, my lord, he has
Now this bar of 7 years operates
yes
against the petitioner.
If it is considered to be a valid mutual transfer order, then so, my lord, he should have been, my lord, subject to correction that, my lord, to not to consider it as a, my lord, valid transfer. Because if it is a mutual transfer, then, my lord, he is.
Yes, you are correct. If petitioner would have been transferred, question of bar would come.
Yes.
Would be implemented or would come into play. But when the petitioner has not been transferred, no question is they have expressed their willingness to get transferred mutually. Then final order of transfer was passed, but that was not given effect to.
Yes.
So there is no wrong on the part of the state authorities,
No.
not permitting him to have access to the portal.
Subsequently, the portal got suspended. Now, he has averred that he has got one partner who is also willing to take mutual transfer, but due to suspension of the portals, he is not able to.
Have you annexed that resignation letter of
Yes, my lord.
of Urpita Mondol?
Yes, my lord. The very next page, page 20.
Page 24.
Yeah.
Then why she has done this?
My lord, she got the better opportunity. She joined the government service. Now this is the difficulty, my lord. I am only praying, let my pair be considered.
In one matter, I do not know what appellate court has done. I was taking matters irrespective of classification 3 years back. Then one teacher, after expressing willingness on portal, after the mutual transfer order was passed, that teacher was not willing to take transfer. As a result, whereof another teacher could not get the benefit of transfer. I imposed cost of rupees 50,000.
And my lord,
This is a joint application.
Both
have
the position is, my lord, I have taken instruction. My lord, your lordship knows that by my lord, last extension order of the suspension of the portal, my lord, the mutual transfer order was, my lord, kept aside. Mutual transfer was kept aside. My lord, that is, it should be in operation, but my lord, my instruction is till date, my lord, it has not been, my lord, operative. The portal is under, my lord, maintenance by the state authority. Soon it will be.
No, the bar is that once you are mutually transferred, you cannot be transferred mutually or normal general transfer. Either way.
This is not his case, my lord. That he is
7 years there will be no transfer. Not mutually, not general transfer.
but here, while this bar subject to correction is not, my lord, should not be,
Very such provision.
my lord, because the facts of the case, my lord, is that I did not, my lord, have given any. In my part, there is no such, my lord, unwillingness to, my lord, avail my transfer, because this is the situation. This is a out of, my lord, any extraordinary situation.
So subsequently, you have not tried or you have not made any application for transfer.
My lord,
But you are apprehending that when you will.
No, my lord, I have.
No, my lord.
Since
his prayer is, my lord, to the make the Utsosi portal operative so that he can apply appeals.
That depends upon the decision of the authority. It is now suspended. I cannot direct them to revive the portal for so that you can have access. It's an order by the authority. Court is passing order since it is on a separate issue.
Yes.
That the statutory right of a teacher cannot be curtailed by an administrative decision. But that is completely different thing. But what is your prayer? That
Now,
is
my
not
lord,
clear to me.
What happened?
Once he is due to the suspension, he is not able to make a fresh application.
Suspension, not because of this locking status.
Locking status in the
Shall not be directed to cancel
portal is inoperative. Locking status.
Issue. Affidavit service filed on behalf of the petitioner is taken on record. Petitioner made an application for mutual transfer along with one Urpita Mondol, based on which a transfer order was passed by the President West Bengal Board of Secondary Education on 8 February 2021. Permitting the petitioner and said Urpita Mondol to be transferred mutually. Stop. Unfortunately, after the transfer order was passed on 8 February 2021, State Urpita Mondol tendered resignation from the post of teacher with effect from 9th February 2021. and which is corroborated from a document at page 24 of the writ petition. Stop. It is submitted. Stop. A concern is expressed on behalf of the petitioner since since mutual transfer order was passed on 8 February 2021. In future, he will not be able to apply for transfer for a particular period.
No, my lord, the rule is, my lord, for the lifetime. Rest of his salary.
He will not be able to make application for transfer, and a statutory bar will operate against him. Next paragraph. Respondents are represented by learned advocates, and it is submitted on behalf of West Bengal Central School Service Commission. Once a teacher is transferred mutually, he or she will not be permitted to have access to the transfer portal, or he or she will not have have access to designated portal for transfer.
Rule 6.
That is for mutual transfer. But for other transfer?
No. Other transfer, my lord, is guided by the, my lord, 2015.
So is there any bar for other transfer?
Bar, my lord, in case of, my lord, the distance ground, there is a bar.
For period of
5 years.
7 years. 7 years.
That was subsequently amended.
7.
কি বলছিলেন বলো তো, ওইটাই আমি বলতে চাচ্ছিলাম। He will not be able to get it out. He will not be able to make transfer application on general ground for a specified period, and during entire tenure of the petitioner, further opportunity shall not be provided to the petitioner for transfer on mutual ground, or further opportunity shall not be provided to the petitioner for mutual transfer. Next paragraph. Having considered the respective submissions made on behalf of the parties, this court finds that based on application made by the petitioner seeking mutual transfer, along with said Urpita Mondol, though transfer order was passed on 8 February 2021, but that could not be given effect to, for which no fault is attributable to the petitioner. It is due to failure on the part of said Urpita Mondol to join the transferred post, coupled with tendering resignation with effect from 9th February 2021, petitioner could not join the transferred post. Stop. Next paragraph. In view of aforesaid scenario, the concerned respondent authorities are directed to permit the petitioner to get the benefit of transfer without considering mutual transfer order dated 8 February 2021. if otherwise petitioner is eligible to get the benefit of transfer. Stop. Next paragraph. The writ petition stands disposed of. Urgent xerox of the writ petition.
Only one thing in the document recorded as per as my submission, that there is no bar for in case of general transfer, if a teacher is mutually transferred once, no bar.
No, Mr. Dr. Patro, if a petitioner is, if a candidate is mutually transferred for a period of 5 years, there is a bar. For general transfer, no.
No. No, my lord.
Once, that is restricted to mutual transfer only.
Now, whatever is provided in the 2016 rule or the as
Amended.
that will now apply to the end.
My lord.
That is a different mode of transfer.
So therefore, there is no nexus in between the mutual transfer and the transfer on general ground and transfer on medical. Medical ground is completely different thing. Transfer on, suppose a teacher is transferred mutually on a particular date. Within a period of 6 months or 1 year, if petitioner prays for transfer on the ground of distance, whether that transfer application is maintainable.
Possibly not. Possibly not. I have to see.
No.
Because the
Already-
time is to be calculated from the date he was appointed in that particular.
ঠিক আছে
I'm getting. Well, 2015 rules, there was a bar that once in a service period, mutual transfer is applicable.
Yes, call the list.
Item number 15.
I am for the I served school also received.
You are for the petitioner?
I am for the
Yes.
Petitioner appointed in 2011. Petitioner applied for general transfer on medical ground. Page 20. Last application made on my lord. 22nd April 2022. It was
Page 20, page
forwarded
20.
to the my lord West Bengal School Service Commission. This is the last application. Serial number 3. Application date.
Medical ground application.
Medical ground.
Self-medical ground.
No, man. On the basis of the report of the COMH. My lord, last.
Yes, yes, self-medical.
Self-medical ground.
Yes. Head of the institution issued
22nd April 2022.
Yes, madam. CMH data কোথায়?
7th June. It was forwarded to the West Bengal School Service Commission.
Please do. But your previous application was not on medical ground.
Not on medical ground. Last application was on medical ground.
So why there was shift from general ground to medical ground?
The medical certificate, it appears from page 23. She is unable to perform her regular duties. This is the opinion of the
Unable to
perform her regular duties. Distance, my lord. And my lord, I have analyzed.
No, why you became wiser subsequently? First you applied on the ground of distance. When this application was rejected by DI, then medical ground. Yes.
I cannot explain it.
Changing lanes
I cannot explain.
by a negligent or rash driver. Yes.
Why that? Why the experienced? He's
So
experienced.
have you annexed the medical report?
Yes. Page 23.
23.
Page 20. QMH report.
দেখি কি বলছে।
It is incapable. এটা কি CMOH এটা?
CMOH. Department of Valuable Government.
নিচে কিন্তু সিল নেই দেখো।
It's not a CMOH report.
এটা কি CMOH?
I have that. This certificate.
বোঝা যাচ্ছে। BADH.
And it is dated
Dated
2022 4 June 2022.
4th June. As 7th June, it was forwarded. I think that certificate is I do.
And the reasons why not?
I do not have that certificate. CMI certificate I do not have.
Self-medical ground, let it
Yes,
be
yes,
decided.
consider.
Self-medical ground, let it be decided.
Yes.
DI has forwarded it. Affidavit service filed on behalf of the petitioner is taken on record. Next paragraph, matter relates to transfer of the petitioner. Since she is suffering from gynecological disorder, stop. Petitioner made an application for transfer on Utsotsi portal on 22nd April 2022, which was forwarded by the school authority where petitioner is presently working, along with no objection certificate to the concerned district inspector of schools within bracket AC for taking further steps. যেটা addition হচ্ছে করবে আর দেখা করবে বিভাগ এরকম করছো যেমন খুশি তাড়াহুড়ো করে stop. On receipt of transfer application, consent করবে না, District Inspector of Schools AC processed the transfer application and forwarded the same through portal on 7 June 2022 to the West Bengal Central School Service Commission for taking final decision. Stop. It has been specifically endorsed while forwarding the transfer application by the District Inspector of Schools that the school has issued no objection certificate and concerned CMOH has also issued medical certificate in favor of the petitioner. Stop. Grievance of the petitioner is in spite of receipt of transfer application by the West Bengal Central School Service Commission, as yet no decision has been taken. Next paragraph. Respondents are represented by learned advocates who have jointly submitted due to suspension of portal with effect from 29th September 2022. Contemporaneously, decision could not be taken on transfer application. Next paragraph. However, on behalf of Commission, it is submitted if concerned authority is directed, transfer application shall be decided in accordance with law. Next paragraph. Having considered the submissions made on behalf of the parties, writ petition stands disposed of, directing the chairman, West Bengal Central School Service Commission, being respondent number 4, to decide the transfer application of the petitioner by 6 weeks from the date of communication of this order, and the decision shall be communicated to the petitioner by 10 days thereafter. Next paragraph. It is made clear that suspension of portal shall not be a ground to reject the transfer application of the petitioner. Stop. Urgent Xerox and wait for
Problem.
Item number 16.
And for the state.
Yes.
The writ petitioner was an assistant teacher in Shombilani High Madrasa. His service was terminated. There were false allegations against him, criminal charges framed against him, and his services were terminated. Ultimately, he stands acquitted pursuant to orders of court, and he is reinstated in service. Lordship, the dispute today is with the quantum of the amount he will receive for the period when he was wrongly terminated after being reinstated.
So you want the full salary adjusting subsistence allowance?
There has been an order to that effect also. The DI of schools has passed an order declaring that approximately 26 lakhs 55,384 is due and payable to me. But if this amount, although there has been an order to that effect, is not being paid. Lordship will only take page 45 and 46. These are the orders of the DI. Lordship will find at page 45. Lordship will find an office memorandum. The arrear is claimed by the school authority of Badulara Shombilani High
Madrasa.
Village, Badulara, Badulara, in favor of Satyajit Roy, the petitioner, the school amounting to 25,384 only for the period 1st February 2018 to 30th April 2020 due to suspension, dismissal from service due to detention, and the VAC Act is hereby sanctioned after reading the director to department.
This amount has not been cleared.
Amount is not being paid. But you will kindly take 46 also. Your Lordship, I will not trouble the same thing, only the last paragraph. Necessary fund as per enclosed, this may be allotted for payment of arrear fee and allowances for the concerned teaching and non-teaching employees. So this is where we stand. We only want this amount to be paid to us.
Yes.
That is our stand also. We have allowed it. We have sent to the DME. Unless the DME approves it, we are not being able to disburse it.
It has already been
We have sent. We have
decided that this amount is payable to the petitioner.
absolutely. We have sent it to the DME for releasing of the fund. Then we can disburse it. That is my instruction. No, I'm not for DME.
State represents the DME.
Yes.
No.
State represents the DME.
Yes.
No, that I have to take instruction then.
Director of Medical Education is represented
Possibly,
by you.
yes. But I received only DI's instruction. I'll need some time so that I will talk to them and the instruction DME Give me some time, my lord. I just received today morning the DI's instruction. That, my lord, I would come back with instruction. I was of the understanding some other advocate appears for the madrasa.
ভাই ওই তোর আছে দেখো
লুকোনো আছে
জুনিয়রের মতো নয় আচ্ছা আচ্ছা
অঙ্কন 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 ইনস্ট্রাকশন নিতে হবে কিন্তু দিয়ে দিতে এটা নোট না আর আগের দিনে 2000 টাকা কে ছিল সেটা বলতে হবে
Come to page 46, Mr. Light.
Yes. I was on 46 only. 21st
Last
February.
2 lines, area bills. Bill has been checked by this office and vetted by the joint director of accounts.
He's entitled. He's entitled.
Remains.
Yes, nothing remains.
To
Just
release,
give me some
direct the
time.
director of medical education, director of madrasa education to allot the fund within certain time.
Yes.
And release the amount to the petitioner.
Absolutely. Absolutely. I hope there is no other legal impediment in releasing that.
Because the issue is determined by the DI.
Yes.
There is no dispute or quarrel regarding entitlement of the petitioner to receive the area dues. Only thing is allotment of
Allotment
fund.
is
Nothing else.
Yes. If he's otherwise eligible, no problem with that. I will not stand in the way.
Your affidavit service.
May I find it within the course of the day?
Affidavit, learned advocate representing the petitioner undertakes to file affidavit of service in course of this day. However, state respondents and West Bengal Board of Madrasa Education are represented by learned advocate. Next paragraph. It is submitted by the learned advocate representing the petitioner that that disciplinary proceeding was initiated against the petitioner and petitioner was placed under suspension. Stop. Ultimately, petitioner was exonerated from charges, resulting in resumption of duty by the petitioner as assistant teacher of Badulara Sammilani High Madrasa. Stop. It is further submitted in reference to documents, reference to 2 documents at page 45 and 46, pages 45 and 46 of the petition, that the District Inspector of Schools AC Bankura has determined the entitlement of the petitioner to receive area dues, area dues towards area salary, adjusting subsistence allowance. Stop. The amount was the subsistence allowance. Stop. Rupees 26,55,384 was found to be payable to the petitioner, as it emanates from 2 memoranda dated 21st February 2024. Memoranda, both 2 memoranda, both dated 21st February 2024. Stop. in the memorandum dated 21st February 2024, being number 339/S, it is further stated by the District Inspector of Schools within bracket AC close bracket Bankura that Arrear bill has been checked by the District Inspector of Schools, by the concerned District Inspector of Schools, and was vetted by the Joint Director of Accounts within bracket Education Department close bracket comma Bankura. Next paragraph. Stop. Next paragraph. Prayer is made on behalf of the petitioner to release arrear dues in terms of memo dated 21st February 2024, issued by the District Inspector of Schools within bracket AC close bracket Bankura expeditiously. Next paragraph. State respondents and West Bengal Board of Madrasa Education. Next paragraph. Learned advocates representing the state respondents and West Bengal Madrasa. Learned advocate representing the state respondents submits that proposal has already been sent to the Director of Madrasa Education West Bengal for allotting fund, which would enable the concerned District Inspector of Schools within bracket AC to release the arrear dues. Since fund has not yet been allotted, payment could not be made in favor of the petitioner. Next paragraph. Having considered the respective submissions made on behalf of the parties, petition stands disposed of, directing the Director of Madrasa Education West Bengal, being respondent number 2, to allot fund based on memo dated 21st February 2024, issued by the District Inspector of Schools within bracket AC close bracket Bankura, being number 339/S, by fortnight from the date of communication of this order. On fund being allotted, the District Inspector of Schools AC Bankura, being respondent number 4, is directed to release the amount in favor of the petitioner by fortnight thereafter. Next paragraph. With the aforesaid directions, writ petition stands disposed of.
My submission on instruction. I've received instruction. Let that be recorded.
Yes, yes.
I'm submitting on instruction. That may be recorded.
দেখি এটা কি সাবমিশনটা কত দেখি ডায়েরি submits on instructions.
Yes, I'm grateful to Lord.
Always Mr. Lahiri adds something at the end.
শেষ ভালো যা সব ভালো তা that's a saying.
Next.
Item number 17.
Petition. Yes.
And I am for the school authority.
State. What is the matter about?
The picture is paying for return benefits under over 2009. He is given the he retired from service in the month of November 2016.
November 2016.
And personal effect from 1
Rupa came 19 came into effect from 1st January 2016.
So he is entitled for the benefit of Rupa 19. That has not been given. What happened here?
But can it be decided in absence of the state?
One thing is that
School has nothing to do with the
school has, because what DI has said.
School is mischief maker.
Yes.
No, he is the mischief maker.
No, I'm telling you.
He was put under suspension, criminal cases pending.
By the managing
After
committee.
series of litigations, provisional pension has been allowed to be given, that is in 2023. And he did never approach to the school for revision of pay under Rupa 19. So this is the position.
So now you are in receipt of provisional pension.
Provisional pension. I'm telling you. At the verge of retirement, one criminal case was initiated by.
You are under suspension.
He was under suspension.
I was under suspension, although I was not arrested. I got the administrative bail.
Thank God you are not arrested.
But then I returned.
So there was no deemed suspension.
No.
Never you were placed under suspension.
Yes, yes.
Suspension order was passed.
Suspension order was passed.
No, if suspension order was passed, subsequently it was lifted and you were allowed to resume duty.
No.
Till the date of retirement,
Yeah,
you were
yeah.
under suspension.
Under suspension.
Just at the verge
Criminal
of
case
retirement,
is still pending.
at the verge of
Because
retirement,
the subsistence allowance is paid considering the last pay drawn by the incumbent in the case of suspension. Think about the provision of Rule 29(7)(a) of Management Rules of 1969.
29(7)(a).
What does it say? Rule 29(8)(7)(a). Rule 28(9)(7)(a).
Management.
Provisional pension, several cases were filed at that relevant point of time. That the provisional pension is to be paid at a rate, at the existing rate, or at the rate which petitioner, at the rate of pay which petitioner was receiving or incumbent was receiving on the date he was placed under suspension. Then it was clarified, relying upon Rule 28(9)(7)(a), that it is to be on the basis of last pay drawn on the date of suspension. So why this analogy will not apply in your case? I could understand that subsequently you were permitted to resume your duty. And there was upgradation of pay in terms of ROPA 2019. Then question of entitlement to receive retirement dues in terms of ROPA 2019 would come into for consideration. But if you are never permitted to resume duty, lifting suspension until the date of your superannuation, then on the date of your suspension, what was your pay, that should be given effect to, that should be taken into consideration.
One order I will place, my lord, challenging the suspension order. I filed a writ petition. It was placed under suspension on 4/4/2015.
Yes, Mr. Hussain, read it. Loudly, let us hear you. Rule 20, yes, right, your right hand side.
To suspend a teacher or an employee where such suspension is in the interest of the institution, pending trial of proceedings against the person concerned within 90 days from the date of suspension, and during the period of suspension, the person concerned shall be paid pay and allowances equal to 50% of the pay and allowances drawn by him immediately before such suspension.
Yes.
This regarding subsistence allowance.
So therefore, in the event of payment of your provisional pension, why this will not be considered? Show me any different rule.
Contrary judgment or rule.
Your lordship has passed order.
Yesterday, Mr. Robilal Mitra was appearing in a matter. It's a case of 302. Petitioner was a non-teaching staff of his clerk in a school. He was in a custody for a period of 8 years. He joined the school in the month of on 23rd of June 2022 and retired on 30th June 2022. Question came in whether petitioner is to get the benefit of ROPA 2019 or not. At the initial stage, I have denied.
What is the fate of that matter?
Yesterday it was heard, direction for affidavit, but at this stage, no.
May I place one order passed by this honorable court?
Very well, you serve notice upon the state, because in absence of state, yesterday's matter, I had to take decision based on it. There are other twists in the matter based on the report filed by the District Inspector of Schools.
DI has admitted in his letter that UET entitled to get
Serve a notice. I am fixing another date. But when I will be able to take up, I do not know.
No, jurisdiction is
matter,
determination heavy.
Higher education is before you.
শুনছো তো সঠিকভাবে নেবে হাঁটিও না বাবা
কে এ করলেন তাহলে কি এই দরজা বন্ধ ও
না
এই দরজাটা উঠে না
affidavit of service you are filing today. Affidavit of service filed on behalf of the petitioner is taken on record. Petitioner, next paragraph, petitioner prays for upgradation of family pension, upgradation of provisional pension in terms of ROPA 2019, which has been denied to him or her, which has been denied to him since petitioner was under suspension since petitioner was under suspension on being implicated in a criminal proceeding. It is also submitted that petitioner remained under suspension till the date of his superannuation, and thereafter he was sanctioned provisional pension in terms of ROPA 2009, not under ROPA 2019. Stop. The learned advocate representing the petitioner submits, considering date of retirement of the petitioner, he is entitled to receive consolidation of provisional pension in terms of ROPA 2019. Next paragraph. School authorities represented by learned advocate. Stop. However, state respondents are not represented. Next paragraph. Learned advocate for the petitioner is directed to serve notice upon the learned advocate representing the state respondents by up to Tuesday holiday or Monday?
Up to Monday.
By 4th April 2025. Next paragraph. List the matter under the heading motion on 21st April 2025.
Item number 18.
I'm grateful.
So let it appear under the appropriate heading. Why it has come?
Well,
may
List the matter.
indicate one thing, well, there may be an issue of maintainability which I will take.
List the matter under the heading interest on gratuity in the monthly combined list of April 2025. Next. Yes, enter your appearance.
Item number 19.
Yes. No order was passed.
My lord, I am appearing. In this matter, my lord, I am appearing on behalf of the state, my lord.
Yes, what is the matter about?
After 65 years, then my lord, the amount entitled to 3 lakhs, but paid my lord not.
Yes.
Other person also.
Petitioner
Yes,
is
my
able
lord.
to get one-time payment of 3 lakhs. Why 1 lakh has been paid?
Yes, my lord. In this matter, my lord, before coming to that point, my lord, the petitioner's prayer, my lord, just 3 lakhs. My lord, it is notification, my lord, in the year of which has been
There
passed,
is a
my lord, year of-
technical snag. There is no continuity in submission which is being made by you.
Yes, my lord, just my lord.
And it is
kindly
repeatedly being
consult-
done. Last occasion also it happened. Then I have to direct the district education officer to submit a report as to
Yes, my
why
lord.
the amount is not being paid. Yes.
But I'm for the my lord,
Now the petitioner retired while retired from the post of para teacher or Shikha Samprosarok. Shikha Samprosarok. Now it is contended that petitioner is entitled to get one-time lump sum amount of rupees 3 lakhs. But instead of 3 lakhs, he has been paid 1 lakh.
or the persons who exercise option to retire at the age of 60, for them 3 lakhs was my lord sanction. And the persons who opted to continue 65, for them that was 1 lakh. Now,
This is the difference.
this is the
65
difference.
and 60.
Yes, my lord.
Samprosarok and para teacher.
At par with para teacher. Now, after 2024, all are entitled to get 5 lakhs at a particular date is there. But I believe this is a case prior to this enhancement and in between that period. Now, if he continue till 65, then we are unable to
Whether the
provide.
petitioner has retired at the age of 65 or 60. 65. Then if he has retired at the age of 65 from the post of Samprosarok, then what is his entitlement?
1 lakh.
Where is the wrong?
I can file a report before lordship annexing all the circulars.
Yes.
That I
File a
can do.
report. Where is the wrong?
No, wrong, my lord, the kindly discuss.
You will work up to 65 years, not 60, and you will get the same benefit. So far, the other retirees who retired at the age of 60, how this can be reconciled?
So, my lord, after my lord, kindly.
গাছের এবং তলার দুটো তো একসঙ্গে হবে না।
And the year of 2022, my lord retired.
60 and 65, my lord. 60 and 65 not different, my lord, circular, you know. And this is the page.
Yeah, Mr. In your report, you disclose the relevant circular.
Yes.
Government order.
I shall annex all those circulars.
And the notification, my lord, upon which the petitioner is
Yes, sir.
relying upon, that notification has been released on in the year of 2024.
Yes, your presence is justified.
Yes, my lord.
Your presence is justified. Last occasion, I had to adjourn the matter.
And all copies are not being served upon the mission director. We are getting information.
When you have retired,
And I have retired, my lord.
why you are appearing online?
My lord, actually, I came to the Madras, my lord, for treatment of the family member. My lord, that's why that is the difficulty, my lord.
31st July 2022, you retired. And you have filed this writ petition in 2025.
Yes, my lord, actually.
You are very vigilant
So, kindly consider,
in,
my lord.
in exercising your right.
Before that, my lord, the representation has been given. My lord, when he has got the information.
File your affidavits, Mr.
Yes, my lord.
Jahan. Yes.
Then, my lord, he has filed. When he has got information, my lord. Other
Petitioner,
person has got the same.
affidavit, where is the affidavit service? Affidavit service filed on behalf of the petitioner is taken on record. Next paragraph. Petitioner retired on superannuation from the post of Samprosarok in a madrasa শিক্ষা কেন্দ্র or মাধ্যমিক শিক্ষা কেন্দ্র?
Should be madhyamik shikha
in মাধ্যমিক শিক্ষা কেন্দ্র on 31st July 2022 and got the monetary benefits which and got monetary benefits. Stop. It is submitted on behalf of the petitioner that he is entitled to get more benefits in terms of the relevant government orders, which has been denied to him. Next paragraph. However, petitioner retired on superannuation on 31st July 2022 on attaining age of 60 years, and present writ petition has been filed on 13th March 2025, comma, precisely after 2.5 years. Next paragraph. Pashchimbongo Rajya Shikha Mission and state respondents are represented by learned advocates. Stop. Issue needs to be decided on exchange of affidavits. Next paragraph. Let affidavit in opposition to this writ petition be filed by 4 weeks from date. Stop. Affidavit in reply thereto, if any, be filed by 2 weeks thereafter. Next paragraph. Petitioner shall be at liberty to mention the matter before the appropriate bench for hearing after the time fixed herein above for exchanging affidavits.
Subject to correction, he retired at the age of 60 after completion of
65 years. Oh, that's right. দেখো তো কি বললো?
17 years.
At the age of 65 years. Right.
Great.
Date is fixed, if it's taken up.
No, sorry. Not possible.
Yes,
Next matter. Next matter. Please don't waste court's time.
Item number 20.
You are coming
Much
after
obliged.
question of fixation of date.
When he has got
If you go on submitting, I will impose cost. Be reasonable before the court. Yes, next matter.
Same. Same and identity.
Kindly record.
At the age of when retired?
65.
65.
When date of retirement?
31st March, Lordship. And 1st April.
31st March
2024. And he say that what is the previous-
মাধ্যমিক সম্প্রসারকের মাধ্যমিক শিক্ষা কেন্দ্র
Yes.
রিটায়ার্ড at the age of 60 years 65 years শোনো ওটা এক অর্ডার হবে শুধু ডেট অফ রিটায়ারমেন্ট 31st March 2024 আর 65 years filed on 13th March 2025 writ petition. Same order.
Good.
Every year satisfied.
602. Item number 21.
But 21, 3% additional increment.
3% additional increment. Give the order. Retired person.
Yes.
Retired petitioner is retired.
On 29th February 2022.
এই শোনো 3% additional increment এর অর্ডার ইউজুয়াল পাস করেছি অর্পণ নিয়েছিল এইটা এটাকে একদম ইয়ে করে দেবো কিছু করার নেই সেম অর্ডার ডিসপোজড অফ নাম দিয়ে যাবে নেক্সট
Item number 22.
Dear my lord. My lord, I am bring matter will be withdrawn, delivered. I will take and there is some mistakes in it.
issue
2016 selection process, my lord, paid for transfer.
18.
Your writ petition will be dismissed with liberty to file afresh in accordance with law if situations so arise. 20 class 9, 10 or 11, 12.
My lord, 9, 10, my lord. Page 14.
Yes, 9, 10, page 15. Acha. Affidavit of service.
Yes, yes.
Affidavit of service filed on behalf of the petitioner is taken on record. Petitioner was selected for the post of assistant teacher in class for class 9, 10 in a government aided recognized school on being selected in first state level selection test 2016. Stop. Petitioner prays for transfer from his present school to another school. Next paragraph. Learned advocate representing the respondent authorities submit. Learned advocates representing the respondent authorities submit that entire selection process, that is first state level selection test 2016 within bracket classes 9, 10, 11 and 12 close bracket has been set aside by the Honorable Division Bench and issue is pending before the Honorable Supreme Court. Next paragraph. In view of pendency of the issue before the Honorable Supreme Court, no order need be passed at this stage. Stop. Writ petition stands dismissed. Next paragraph. However, this order shall not preclude the petitioner to take steps in accordance with law in future if situation so arises. Urgent xerox certificate copy. Next.
I will say.
Exactly.
When it will fall down, then I shall be.
19.
I will follow the serial number. Sorry.
Item number 23.
Be exactly same, maybe identical, maybe similar.
Number 23.
Yes.
For item number 23,
Not today. Why?
I think Mr. Jana is engaged in another court matter.
At the time of call, accommodation has been prayed for on behalf of the petitioner. However, respondents are not represented. Next paragraph lists the matter under the heading motion in the monthly combined list of April 2025. Next.
Lordship, in item number 24. Lordship, in item number 24, Mr. Shantanu Kumar Mitra is
What is the matter of?
This is the matter regarding higher scale of pay upon acquiring higher qualification.
Who is appearing?
Lordship, Mr. Shantanu Kumar Mitra is appearing. He is engaged in courtroom number 654. Lordship.
If you pray for time, it will go to the next month list. Yes.
Item number 25.
Same, 910.
19.
910, which page?
My lord, page 13.
এই ওই যেটা করলাম SLST 2016 classes 9 and 10 same order.
Appearance দিয়ে যাবে affidavit service.
Service.
Next.
Item number 26.
Yes.
Lord, without going to the merit of the case, my lord, I am placing before Lordship one representation for reorganization of the managing committee has been prayed before the authority. That has been pending. At
Service.
Service has been pending.
Who are the parties?
I am for the
Authority,
board.
Secretary
Lordship.
of the managing committee.
We have made the party respondent number.
Whether the school authority is represented.
My lord, it has been.
Who are you?
My lord, I am the vice president of the earlier managing committee.
What locus you have?
Correct, Lordship. I asked this question to myself also.
Yes.
But during the period of tenure of the managing committee, the administrator was appointed by the authority without finishing the term.
Today, are you related anyway to the school
Lord,
or madrasa?
My lord, at present moment, my lord, my answer would be,
Then you will not get any relief.
my lord, be frankly, my lord, subject to kind sanction.
If you are not related anyway to the madrasa, you have no locus.
My lord, my lord,
One point of time, you may be a member of the managing committee of madrasa,
Lordship.
but that will not improve your case unless and until you can demonstrate before this court that you are related anyway.
But
to
in
the
that event,
madrasa.
can you make it not today so that I can satisfy you in the month?
As prayed for on behalf of the petitioner, hearing of this matter stands adjourned. List the matter under the same heading.
Locus.
Motion. Very well, not today.
In the month of April.
No, not April. Not today.
Tomorrow.
On Tuesday.
No issue. I shall.
Service.
Service রাখবেন?
Lordship says no locus, your worship.
Service রেখে দেন।
Matter may be.
Every service
He's
may be
praying
given
for
the-
time. Let an opportunity be given to come
So that I
prepared.
can satisfy you.
Lord.
But that anyway we have connected on.
Not today করে না চলো হয়েছে
Item number 27.
Petitioner. State. At the time of call, no one appears for the petitioner and no accommodation is spread for. Stop. Writ petition stands dismissed for default. Parties to act. State respondents are represented by learned advocate. You are for the commission? No. State respondents are represented by learned advocate. Next paragraph. Writ petition stands dismissed for default. Parties to act on server copy.
Appearance দিয়ে যাবে।
Next.
Appearance টা দেবে, হ্যাঁ?
Item number 28.
Item number 28 to 33 are similar matters, my lord. Notional benefit, my lord, your lordship, my lord, the judgment. My lord, this is the.
You appeared before. Your matter was considered by the principal secretary. But there is a modification of my order by the.
Not filed by me, another.
Maybe you have a
What
right.
happened, my lord?
Don't
They are the
hesitate, please.
petitioner. They are the petitioner.
claimed we want actual benefit. And that was sent to the division bench, set aside your lordship's order of notional and directed the principal secretary to reconsider that, whether he is entitled to actual benefit or not. Here, my lord, the petitioner have taken instruction, have pleaded. The petitioner doesn't want actual benefit, he wants notional benefit.
But today this court is required to consider
that
view
true, my lord. This
expressed
is
by
the
the honorable division bench.
Yes, my lord. This is the division bench order, my
That
lord.
it is to be reconsidered by the principal secretary.
Yes. This is the division bench order also.
After this order, how I
Yes,
can
that's true.
show me the order.
Division bench order.
এরা অ্যাকচুয়ালি চাইছে না, এখন অনেক সময় লাগবে, আমি ঘোষণাও পাইতাম।
Because I have taken a view that has been set aside by the honorable division bench. Now, if this is the position, now the matter needs to be reconsidered in the light of the decision of the honorable division bench.
Then that order be passed.
We'll come back on.
And if
next day.
actual benefit is given, they will also definitely come say.
Because today, if I pass an order following my previous order, that will be in the teeth of the order of the honorable division bench.
That's true, my lord. Also, one thing, my lord, that particular person has claimed actual benefit.
Then
Here we
again
are-
another round. Then again another round. It is to be reconsidered. Then the petitioners
That
will
is why
again come.
this petitioner said that we do not want actual benefit, because actual benefit will get in 10 years.
No, I will also hear you that if a case is made out that we are seeking notional benefits, then whether it is open to this court.
Yes, I
to follow
specific
its previous order on admission.
On admission.
Yes, but then they will have to give an undertaking.
Then
that
am I
we will
pleading
not
in the petition?
Later on, being a fence sitter for the time
My
being.
pleading in
So
the
I
petition.
will record your undertaking.
Yes, my pleading in the petition.
Come back on the next day.
But I'm filing overload number on behalf of the state, my lord.
Yes, file your pocket. Next day.
Deeply.
আরে এটা ডিপার্টমেন্টে দিয়ে দিই হয়নি তো
Yes.
2 PM fixed matter, item number 71 to 92.
This entire bunch of matters, possibly there are two categories. My matter is at the bottom, para teacher, leftover. Whatever the selection process, whatever the terms and conditions, whether that should be changed in the process or not. In essence, whether the Tej Prakash, now the 5-judge bench have said. So now it is the consistent view. Once the game starts, rules of the game cannot be changed because there are divergent view, matter was referred, went to the Honorable Supreme Court. So I am in the category that there are some leftover vacancies. I have no quarrel with the trained candidates. At that relevant point of time, I did not have the training. But in the meantime, I got the training, but I am not asking that you give me the benefit for training. All I am saying, your advertisement said training and also untrained. As a para teacher, there is a 10%.
What was the advertisement?
It was said both are
Trained and untrained, both
yes,
were
both are eligible. Yes, I said that was the advertisement. So the rules of the game combined with trained, untrained, both are eligible. Now there are 4 subjects I have been able to.
It is under the category of para teachers confined to 10% of the vacancy. Upper primary.
Yes, upper primary. Now I have been able to gather information from their own document. There are 4 subjects. There, after fulfilling all the trained, X number of vacancies are there. We are saying, please accommodate there. Now they take a stand. We can't accommodate because we gave an undertaking before the Honorable Justice, probably Mousumi Bhattacharya, and therefore we cannot give it. We have read the judgment. After reading of the judgment, I find that it seems that the Honorable, firstly, though no undertaking I have been able to find, I find that the Honorable Court has expressed like what they were doing, instead of training, they were taking the untrained. So this is something illegal. So the Honorable Court said that do not do that. So
it was at the stage when trained candidates were not accommodated.
Absolutely. So therefore, Honorable Court rightly said you cannot allow
so now, is it your case, Mr. Dhar, that after accommodating 10 trained candidates under the category of para teacher,
yes,
there are still vacancies left within the purview of 10%?
Well, I need not use even 1 comma. Exactly. Yes, that's my guess. And the law point would
what is your case?
May I just one second.
Today time is
I know that. That's the reason.
The major chunk of the matter that I am representing.
Well, today there is 30 minutes we have. That's it. I thought I know that. Not even 30 minutes. Oh, I didn't. 20 minutes. Sorry. I was just thinking that so that we can give some essence that what is the real thing that
I view
yes.
so that I can give.
Now it seems to me that the SSC stand, because now their stand is we will not take any untrained. If they take this stand, they say that we are taking this stand because of undertaking being given. Now there are 2 possibilities. One, I find this statement itself is incorrect, number 1, which is a very good case. The other, I find, assuming that undertaking is given, assuming as a worst case, can the rules of the game be changed just by giving an undertaking that no, I gave the advertisement this is.
Hello, I just react to what Mr. Dhar is saying because
consolidated reaction
this is just
at the end. Considering time constraints. Yes, Mr. Bhattacharya.
71, 73, 74, 75, 76.
That will be added. What is your case?
Sir, we are all TLS. We have obtained, Milord, the Diploma in Elementary Education degree. Milord, in accordance with the date extended by NCT. The date was extended up to 2019. At the time when the advertisement was published, we did not have that diploma. We have obtained it post. The School Service Commission has said in their affidavit, insofar as these matters are concerned, that since they did not have the requisite qualification, we can't allow them. Now, one of the petitions which may be disposed of today, subject to what
my learned senior friend says, Elisha Chatterjee, item number 84, she is a single petitioner. The date earmarked on the 23rd of August 2023, when this notification was published by the School Service Commission enabling us to upload documents, she missed the bus because her son's examination was there. She could not upload. But she has a B.Ed degree. She is qualified. Everything is in order.
As per the parameters set by the commission.
Them. She just missed the date. And therefore, she is before your lordship court. Only one petitioner. She has her degree from 2003. So this matter can be separated from all this. And this matter may be treated as
separately considered and
and Mr. Dr. Patro may do some justice.
Now, why the commission is eliminating
commission has
your clients for obtaining DLA? What is their position?
Just 2 minutes.
Yes.
When I'm placing the lead matter opposition, the lead matter is apparently item number 92, the last matter, Siddiq Sardar. The affidavit in opposition.
I don't know what my learned friend means by lead matter.
No, this is one of the
should be taken separately, because there is diverse, what should I say, mismatch of the candidates. Even in the same petition, there are candidates.
That was permitted by the coordinate bench. He has not carried an appeal from there. All the petitions have been prepared by petitioners where we have paid the court fees, we have taken leave, and reports are there, and they have also used an affidavit.
Generalized statement as usual. That is the problem I'm facing when I'm appearing in these matters clubbed together. That is a generalized statement. All the matters, there were no directions for affidavits, only some of them.
In the matter, item number 92, my learned senior.
So for the single loan matter, where petitioner could not upload on the date.
Loan matter, there are 3 matters filed
under the same category.
Filed by the same learned advocate on record, but they are not saying item 90, item 91.
90 is my matter and this is not the same matter.
Item
number
91.
What is the I am appearing? Let us understand. Dr. Patro, I will assist him as to who exactly is representing whom. I only said Elisha Chatterjee is a single petitioner, item number 84. There my instructing advocate is Mr. Mohiuddin. That lady could not upload the documents because of this problem.
She was absent. She was called for participating but remained absent.
Whether the grievance was raised before the grievance redressal committee.
No. That committee, that committee, that for the
90%. I'm sorry.
That is not for 10%.
10% not the leftover.
The 10% para teacher category, there is no such.
Of the 100%, how can they segregate themselves?
At that point of time, that was state, my lord. My learned friend know it very well. At that point of time, 10%
so your case is this, that it was open to these 10 candidates under 10% to raise grievance against the.
Yes, because they were entitled. They were entitled to non-reserved seats. Many of them have also been already appointed, having para-teacher qualification, but they came within the 90%. So they have taken their appointments. So grievance with regard to you being a non-BA,
Dr. Patro,
they should have taken
I am asking you that if a teacher, if a candidate under para-teacher category participated,
yes.
Now on the last date he or she could not upload. Now whether it was open to him or her to approach redressal committee.
No, because that was a subsequent event. That was subsequent. But what I'm trying to say is, firstly, as far as this Elisha Chatterjee, as my learned friend is pointing out, subject to correction because I had to work out so many cases, she was called for the physical verification but was absent. First, there was the online verification. If you have not participated in online verification, you will not be called for physical verification.
She was called, but she was absent. ঠিক বলছি ওই বিষ্ণু
বলো বলো নিশ্চয়ই
That's why
similarly situated
Mr. Bhattacharya is not saying anything.
Similarly situated, there are two more candidates before the court. We have taken the ground of delay also. You might be absent, but you ought to react promptly.
I was only praying for disposal of my representation. I have prayed by way of representation for a further date for verification of testimonials.
But that stage is over long back.
No, that stage is still going on.
Uploading, you could not upload.
Uploading stage.
If I allow your uploading today, then I have to allow similarly other candidates.
Greatest of respect for assisting the court, my lord. There is no such provision for online uploading. Well, kindly take the rule position. The rules 12 is specifically
This
stated.
uploading perhaps was made in terms of initiation of second stage of proceedings under rule 12(2).
No.
11th August 2023 notification was published at their instance in respect of 10% below these para teachers. We are concerned with the 10%. Kindly not with
Mix it up.
the other writ petitions, Supreme Court, coordinate bench, everything is pertaining to the main 90%. Here we are concerned with only 10%. As my learned senior Mr. Dhar pointed out, the rules of the game is one issue. In the rules, there is no clear embargo regarding trained or untrained. That can be demonstrated also.
Now, in case of in the cases of Mr. Bhattacharya, they are pursuing DLED course. Why they are not found to be eligible?
So candidates who have the degree at the time of making the online application. This applies to both 90% and the 10% because it was the same selection process. Everybody was making their online application. Rules cannot be separate for the two sets. The court held both while taking our undertaking and while finally disposing of that set of writ petitions, that candidates who have not acquired their degrees and mentioned it in their forms, they cannot be included. That is the language of the rule. The language of the rule is simply having is not enough. Maybe I got my training qualification in 2015.
But it was not indicated in the application
2016 form. So then also I cannot take that candidate even if I want to. The court has shut the door.
So is it the case of Mr. Bhattacharya's client?
Some of them, yes. 23rd September 2016 is the advertisement. If it is not disputed, let us take the date. 23rd September 2016, not first state level selection test for recruitment for assistant teachers upper primary, except physical education, etc. The qualification indicated in that is eligible, both trained and untrained candidates. For first level selection test as per minimum qualification laid by.
Now, if it is qualification is both trained and untrained, then even if this training qualification is not disclosed in the application, how does it matter?
No, because for this part actually the presence of the state is also necessary.
How does it matter, Mr. Dr. Patru?
Because without
it is immaterial.
Without a teacher's training qualification, one cannot be a teacher. His appointment or her appointment.
Then why this eligibility criteria was set?
Yes.
Where eligibility criteria was prescribed, where permitting untrained candidates to apply.
Because in 2016 we were enjoying an relaxation of this provision given by NCT. And since we were enjoying the relaxation, we were carrying on with it. But after 2019, that relaxation was withdrawn. So the state intimated us that you cannot do it. We stopped.
But that is in the midst, after initiation of the selection process.
Yes, but the court has not allowed it. It was challenged. What my learned friend
Paragraph 42. State focus is clear.
Yes,
I'm answering 10 people.
Without
entitled to 10 sentences.
Without hearing you, I will not pass any order. So I will
Mr.
hear all.
Honorable,
Yes.
Thor said,
Yes, yes.
submitted, that we were doing illegal activities and taking non-trained. That is absolutely incorrect.
Not a single non-trained
We-
candidate was taken.
That was the allegation
Then
before
why
the
give the
court.
overcharge to non-trained candidates?
That was
Why
the
give them the chance to apply?
The allegation was raised. We denied it. Court said, file your written instruction. That was filed and that was kept on record.
If in the recruitment notice, both trained and untrained were permitted.
Their
In
appointments, all
the
their
midst,
appointments would
when
have
this
become
selection
legal.
process was continuing, there was a change in view of NCT guidelines or rules that no, unless until you are trained, you have no authority to be appointed as a teacher. Now, does it have any impact? So far, the notification which was issued prior to that. I will hear you. I will hear you on this point because this is the crux of the issue as it appears.
That is so. But these
Has it
matters-
been clarified by Justice Bhattacharjee while considering the matters relating to
Justice
upper
Bhattacharjee considered 90%.
There is
Kindly will not. This issue was never placed.
never considered.
But in one of my just another matter, there was a division bench judgment presided over by the Honorable Justice Contempt. In the entire judgment, after reading, I found nothing has been said regarding this issue. Some clients, whether they've made an application seeking modifications for one sentence, to say that nothing has been said. I appeared there. The Honorable Court just last week clearly expressed on this issue that leftover untrained. If the trained are taken, all vacancies are filled up, no, nothing to do. But if vacancies are there, can you take a, we have not seen anything on it. And I have read, I would definitely, I'm very curious to know from Dr. Patro.
If posts within the ambit of 10% are available after accommodating trained candidates, then what is the difficulty in accommodating untrained candidates taking cue from the recruitment notification?
May I just say one thing? My learned friend, he is saying that we have leftover vacancies.
Yes.
We have not even held the interviews for 10%. So where have the vacancies been used and where have they been?
The
where
entire
are they
vacancies are
leftover?
pending.
They have to make up their mind whether
I have-
one selection process or two separate selections.
With greatest of respect, my lord, eligibility list is already published, my lord. My lord, my lord, that list is emphasizes that our name is not listed and that.
You have to be very
That's our case, my lord.
No, Dr. Patra, I will hear you on this point. If during ongoing selection process, if it is clarified or if it is notified by NCT that unless until you are trained, you don't have any right to be appointed. Now, how does it affect the recruitment notification of 2016? That is, yes.
My lord, may I point?
Yeah, precisely, I could have.
I want answer from clarification from you or argument on this aspect.
Yeah, but I could have understood.
I'm actually
Because if this issue is addressed, then I think most of the matters can be tackled.
And one another.
No vacancy.
Issue.
Another.
one very important matter.
I mean, only this much. I mean, that the
Matters are heard in presence of the learned advocates representing the parties. Stop. List the matters under the same heading.
the same heading হবে now to our অসম্ভব we are going to I'm telling indicating we have talked to the bar association people also we will be it is impossible, inconceivable, everything we can't even disturb your lot for an unlisted matter. It's impossible.
I know something definitely will happen.
No, you never know. He definitely will.
Not possible.
Possible. Possible. মামলা হয়ে যাবে
বেশি হবে
ওই ঘরে আছে এই ঘরে 4-5 জনের মামলা হবে
22nd April 22nd April 2025 as 3 p.m. fixed matter.
Very good.
Let me see.
Yes.
On that,
ইন্ডিকেট অল দ্য ম্যাটার্স
Yeah.
আজকে যে কোনো লিস্টে আছে সমস্ত দেবে নিয়ে একটা অর্ডার করবে আপনাদের দিচ্ছে কিনা আমার দিকটা ফেরত নেওয়া হবে। কেন দিচ্ছে
Taking that proviso, so that every in-service teacher ought to be the train. That proviso is for the in-service teacher, not for the earlier. That's because the year 2017, that provision is.
Group.